if a home is owned by one spouse because the other spouse signed a disclaimer deed, can you list the property with only the owner's signature, or do you need both people's signature to list the property for sale?
It can be kind of tricky. Arizona is a community property state. So with married couples, even if the property was acquired by an individual before marriage happened and things like that, a court could look at it and say, hey, this other party had equitable interest in the home. They've been making, mortgage payments on it, or the mortgage has been paid from a joint bank account, things like that. So it can get a little bit tricky. Now, if there was documentation signed previously, through like a prenuptial agreement, postnuptial agreement, things like that, showing that that property is owned sole and separate by one individual, then you can usually just get one party's signature. But it can be a little bit tricky and it can be a little bit of a gray area. But typically in a real estate transaction, even in a normal real estate transaction, you can proceed on a listing with only one party's signature. You don't always need to have both parties' signature to proceed with the listing.
Okay, I didn't know that. So certainly if it's owned by one party, you can move forward with only that party's signature. But if it's owned by two parties, you can still list that property even if only one person wants to list it for sale.
You can list it, but there can be challenges involved as well, because if that other party wants to kind of fight you on it, that's where it can kind of end up back in the courts and stuff like that. So ideally, I'm always going to want to talk to both parties and have both parties sign the listing agreement, because it's just going to make for a much smoother transaction if we can kind of get everybody on the same page.
Definitely.